Shifting focus to India now, in a landmark order, the Supreme Court has decided to pause its hearing on the Sedition law. This will impact hundreds who have been charged under the Colonial-Era relic. The apex court has said that till the law is being reviewed, those jailed can approach the court for bail, and this comes just a day after the Government of India submitted an affidavit deciding to review the law. The document reads, and I quote, "The Prime Minister believes that the nation needs to work even harder to shed colonial baggage that has passed its utility, which includes outdated colonial laws and practices." Here's what else it goes on to say. The Government of India is fully cognizant of the views being expressed on the subject of sedition and has considered the concerns of civil liberties and human rights while committed to maintain and protect the sovereignty and integrity of this great nation. It has decided to re-examine and reconsider the provisions of Section 124A of the Indian Penal Code. Let's now understand what this law means. It states that a person commits the act of sedition if he or she brings or attempts to bring in hatred, contempt, or disaffection towards the government. The law is vaguely worded and widely abused. The law dates back to the British rule, when it was used to clamp down on dissent against imperialism. Mahatma Gandhi was incidentally one of the famous faces who was tried under this law, but even after India became independent, the law has been rampantly misused. Somehow, even 75 years after independence, sedition remains an ugly truth of independent India, but this might change soon. A review could lead to a possible repeal or an alteration, and this is crucial to not just uphold democracy, but also to protect the space of conflicting opinions in a nation of 1.4 billion people. For more on this, our correspondent Aditi Gupta has sent us the latest report from the heart of the action, the Indian capital. Take a look.
The Supreme Court of India today put a stay on the sedition law and ruled that no new FIR would be lodged under the British-era law until the centre re-examines the provisions of the law which have been challenged before the court. It is for the first time since its inception that the provisions of Section 124A of the IPC have been challenged. In a relief to those who have been booked under the Section 124A of IPC and are languishing in jails, the Supreme Court today said that they could approach the courts for bail. The historic decision of the Supreme Court comes a day after it asked the centre whether the pending sedition cases could be kept in abeyance.
WION World is now available in your country. Download the app now and get all the news updates on the move.